Do have a list of it.
Okay. All right, everyone. We are going to start. And first off, Rashawn is not here, but I'm still gonna say it. Happy Black History Month. And Deputy Laura, you know whose today figure is?
Who's that?
Today's figure is gonna be Constance Motley. Motley.
What did she do?
Hey, that's people. So you got to put a name out there and have people do their research. It's not like back in the day where you had to go to the library, where I used to work with a card catalog.
I worked in the library in college.
Did you have the card catalog?
Yeah,
card
I used
catalog?
to have to go straighten them out.
Let me just tell you, one of my pet peeves, people would come in, they would grab a book off the shelf, and then they would want to put it back. I'm like, leave that book alone. Just leave it on the table. What we're trying to, I'm like, no, because at the end of the year, you have to do inventory and you have to go and find that book. But the worst thing for me about working in the library was shifting books. I never liked to shift the books, but I got to work out. So
Reference librarians are pretty fun. You know, they would get calls, this is way before, now people just Google everything or use AI, and they'd get all kinds of calls.
Oh yeah.
About questions, trivia, whatever, and it was
Well, people would come to me and they would end up asking me about a book. They wouldn't remember the name of it. All they would remember was how the cover looked. I'm like, is it in sci-fi? Where, give me some idea, then I'll be able to tell you. But it was interesting. I loved it.
Yeah.
All right, everyone, I'm going to call the docket. When I call the docket, you need to stand and let me know you're here. Otherwise, I'm going to assume you're not here and a warrant may be issued for your arrest. Custody, Robert Ortiz, Gabriel Martinez. Thank you. Jeremiah Roberto Mark. Brandon McCaskill, custody. Denise Ann Lujan. Fabian Singh. Enrique Lopez, custody. Jesse Martinez, custody. Carlos Antonio Gonzalez. Thank you. Leanne Garcia, custody. Herman Mitchell, custody. Matthew Cadena. Thank you. Enrique Rodriguez, Jezer Calderon, Teresa McCormick, Sebastian Gabriel, Kevin Walker, Brian Berry, Andrew Silva, Stephen Nick, custody. Alfred Anthony Ariola, Sammy Smith, custody. Calvin Medina, Larry Garcia, Jesus Aris Mendez, Summer Muniz, custody. David Cortez Jimenez, Star Bright, custody. James Lloyd, Michael Foss, thank you. Charles Fleming, Devin Grisham, Amanda Balmeris, Titus Ramirez, Christopher Saniga, Brandon McCaskill, custody. Giovanni Batty Jones. Thank you. All right, is there anyone present and your name was not called? All right, attorneys, you know the rules. Please confirm. Megan, happy Black History Month. You do? Okay, what's the name? Oh, people should know Mecca Evers. And let me just tell you, my heart breaks. They don't do it anymore, but I remember in the late 70s, I was in elementary school and they would show those school specials. And you know how the story is going to end, but you're just praying it ends a different way. And my grandmother would always say, you could see like their wives, like the likeness in their eyes just changed. Like my mom said, my grandmother said, Coretta was never the same after Martin died. And then with Eggers and Malcolm, you could see they're just, But yeah, everybody should know Medgar Evers.
What was
The first name I gave was Constance Motley. Oh, yes.
I don't know what page it was on, but Mr. Lord,
Mhm.
they're going to withdraw and amend.
All right,
For
so I'll need, you
observation.
need to let the clerk know so they can put him on the list and then just approach.
Okay, do you?
I need to
does
see
that-
what's going on.
That's my question. Do you want, because he's still at the jail because he's having a mental issue.
Ah,
So do you want them to
Well-
work on getting him here?
well, have them pull his file because I don't know anything about his case.
You haven't changed Lord. Well, we're gonna try to withdraw and amend. But I didn't know. We need to approach a judge to have him here or?
Summer Munoz, you have her?
Yes.
She was supposed to get out of the bar.
Yes.
Bring her up, I guess. Got about 4 cases, so bring her up. They're talking.
Have you talked to the state?
Yes, ma'am. I've talked to the state and probation this morning.
But he has a new case, so what's happening with that?
Well, that's news to me.
Okay, let me check it and see. Let me look. The docket could be wrong. It's been known to happen.
I don't know.
I
I
saw your eyes expand. You're like, what?
Yeah.
Let me see.
didn't know he had a new case if he does. I got an appointed on an MTR and it doesn't show anything new on the MTR.
Let me put it in, because sometimes, you know, Odyssey is what Odyssey is. All right, could I see probation on Mr. James Lord? Probation? Could I see you on James Harold Lord? And do y'all have the court summary?
I'm sorry.
Oh, that's okay. All right, so defense is saying that you all want to withdraw the motion?
That is what the state said, yes, Judge.
Well, now, what do you all want to do?
Well, they're recommending the transfer to the MIC unit.
All right, so do you know, because with the motion to withdraw, and counsel, I'm fine with the motion to withdraw, but these amended conditions, I'm trying to make sure that if conditions are amended, it's something where he won't be back here for violations. So do we know why he had the misreporting? Was that they were related to mental health?
Mental health. The report there is in the front. I think they got it completed. He had a breakdown and.
So do y'all know if he's competent or not?
According to the evaluation, everything we have, he is. And they're ready to transfer him to the unit.
All right. But the screening was done in March.
Yes, ma'am. I think he's been in custody for the whole time. So he's stable now.
Wait a minute. So I need to understand what was happening. So he was in custody why was he in custody since March of 2025?
I don't think he was. I think he was in custody the end of January. That's what I believe, Judge. He was in custody since the end of January, 27th or something like that. At least that's when I got appointed.
All right.
And I think he did not show up. And you have it there, so I'm not hiding anything. He tested positive once for methamphetamine. But they're saying that he's having mental issues, and he was competent at the time. Look back at my record, I don't think we did a competency exam. It wasn't required, if I recall right.
So is this MIC evaluation still,
Yes, it's still good, Judge.
even though it's from March?
Even though it's from March, it hasn't hit the year yet. It usually takes about a year.
Reads like they wanted to do the evaluation, so he's been in the evaluation period,
Mhm.
since he's been in jail, is what I kind of.
But I'm just trying to clear up that he has not been in jail since March, because
I
if
did not.
not, that's a
No,
problem.
I don't believe he has, Judge. I can
So
research that.
is it, yeah, if y'all could look, because if he's been in jail since March, that's a breakdown in communication. But defense, you're saying only since January?
That's what I assumed, because that's when I got appointed.
Okay.
Um,
All right, Deputy Laura, are you able to bring Mr. Lord up? Is that a problem?
Well, I was informed that he's mental and they're having difficulty bringing him over here.
Okay.
That was,
Is it difficulty because it's mental, or if it's difficulty because he's going through a crisis?
A little bit of both. They're trying to convince him to.
Okay. Probation, how you all planning on seeing Mr. Lloyd?
He's going to be on transfer for supervision to the mid-period judge.
No, but I mean, because he's gonna be released from custody once this is withdrawn. Am I correct?
Yes.
So how is he, if he's having a mental crisis right now, or, well, deputy says it's a combination of mental crisis and the fact of his classification, that there's some issues bringing him over. So how's he gonna know where to go?
I'm gonna have to meet, I would have to meet with him on Zoom meeting.
Deputy Laura, see if they can have him by Zoom, All right.
Already ordered him product.
as ASAP, so that probation can speak to him.
Chevy said to bring him over.
Oh, do they have him over already?
No, but they're removing him, they're putting him into the van last I checked.
All right, can you see, because I want to make sure that he doesn't, if he fails to report, they're just gonna file another motion to revoke. And I want him to be on notice, and then we'll see if he's
I'm gonna run to
mentally able to put in notice.
399.
Okay. All right, thank you. Judge, how about- okay.
It's just like.
Yeah, anyone else ready?
Nobody right now.
Okay.
Is there anything else?
So you're saying plus.
This is nice. Those voices in your head are loud. I could even hear them. Do you see how they're on the bottom?
The state, I wanna show you. Some, you know. You guys take it out. Why is it one thing?
Yeah.
Trying to.
Yeah.
Yes, it's me.
Yeah.
We cannot.
Do we need WD-40? What's going on?
This morning. Some of it's easy. NPR. MUNIC.
Oh.
Yes.
But isn't it?
Oh, yes. I will hear you. I'm gonna try your. Seconds up. Six, yeah.
It's now for there. Issues today. Thank you. They bring him on the bus, he's having, behavioral issues.
Oh, so we could just do it by Zoom, that would be fine.
I can't find it right now.
He's not up. No, what you.
And I thought.
He'll be on short.
Serious?
I
Right, yeah, I'm trying to wrap them all up.
Yeah, not in the first row. Not in the first two rows.
What are you doing today? Yeah. Cause I ordered. Here's what I want to know. What am I doing? Wait, else? I just be Amazon stuff.
It'll be coming up shortly.
Oh, no. Yeah, you know what?
This is the.
Oh, I know where it is.
The lawyer. Cause his bag, I said next to his bag and so
Sometimes court, it's a lot of waiting around.
No.
You have to wait for the parties to come. And sometimes the parties will have cases in other.
Yeah, that's, I got it right. Oh.
Sometimes they're in trial in other places. And so a lot of it is about being patient. And the only time there's an issue with attorneys not being present is if we have a jury trial scheduled and jurors are waiting. So, yeah. All righty, who's ready?
First one will be H3, first one. Herman Mitchell.
Okay. All right, Herman Mitchell.
Hello.
Good morning. Let me see. All right, so on this case, where are we on discovery?
Judge, I have all the discovery. I've been tendered an offer.
Okay.
My client just wants some time to think about it.
And sir, how old are you? All right.
My sister has a problem, she's on dialysis and everything.
Mhm.
I take care of her.
He wants to talk to his sister, basically, Judge.
Okay. So do you know when you'll have a chance to talk to your sister? Will you be able to receive a phone call from her or call her?
I can call her, but she's in dialysis today and she doesn't get out till late this evening, and then when she gets home, she's tired. So she goes and she lays down and there's nobody really there to help her. I'm the only one that helps her, and I'll call her tomorrow in the morning.
All right. Do you want me to, what I can do then is I'll recall this for a plea deadline date in 2 weeks. And then if you want it brought back sooner, we can have it brought back sooner.
I think that's good, Judge, yeah.
All right, Ms. Ferguson, I need a 2-week reset for a plea deadline date.
February 23rd.
Can it be, sorry,
Sure.
I'm getting back from my vacation that day. Can it be the next day for food?
All right, so February 24th.
Yes, Judge.
All right, thank you. We'll see you back then.
Thank you.
Thank you. Oh, thank you. All right, who else is ready?
Okay, 4, second down. Kevin Walker.
Kevin Walker.
What's your name? Yeah, sure. Why did it change your name?
Hello. All right, on this case, where are we on discovery?
It's on. The state is in the process of getting some more jail calls to give us, so we have everything but those, but there is about 1,000 coming. Rick has like 200 so far, but he said depending on the contents of those jail calls, we got like a tentative offer today, but that offer may drastically change depending on what is or is not in the calls.
All right, Ms. Ferguson, I need a plea deadline date for 30 days, please.
Yep. I can do March 12th.
All right, we'll see you back on March 12th.
Thank you, Judge.
All right, thank you. Anyone else ready?
Next, week 7, third one down, and then if you recommend.
Can you give me the credit for time served on this lady, my client?
On this one, do you have the stipulations?
I can give it for you.
All right, thank you. All right, are the parties ready on Michael Foss? All right, and do you know, was it Megan? Okay, just give us a moment. I think she'll be right back. She had to, I think, go upstairs or something.
Okay.
Okay. But just let me know when she comes in and then we'll take it up.
Running out of time here. Trial.
Ah, just 1 second. Norma, could you call Ms. Galloway?
Yeah.
All right, who's next?
That's all I have for now.
All right, thank you.
I'm putting it.
Okay, thank you. All right, thank you.
She's on her way.
All right, thank you.
On page one. Mr. Hockey, can you get feed and trial 47? Go through the whole pattern, no contact with the phone.
Okay, I'll take it up.
He'll be second in.
Okay.
But you forgot when he's trying to.
All right, thank you.
That one is a violation of the one. Original one.
Morning, how are you? How are you?
Yeah, we're not in position.
Thank you.
Jason, please.
And I was coming to see maybe if I did or if I didn't. I know that the case that was originally set up. Yeah.
Okay, are you all ready to proceed on Michael Foss?
Yes.
All right, the court is calling 2025 CR 002-639 State versus Michael Anthony Foz. Can I have parties announced for the record?
Arlene Gay for the defendant.
Right, and are you Mr. Foz? All right, you entered a plea of true to violations 2 and 4 on February 6th. The court found that there was sufficient evidence to find it true. The court found it true. And so we're here today for witnesses to be presented.
We do have a witness.
All right, and state, do you have any witnesses? All right, defense, you may call your witness.
The defense calls Priscilla Garza. I'm sorry, Garza. Who is in the courtroom?
Mr. Fox, put your back against the counter over here.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand if you'll state your name for the record.
Priscilla Garza.
All right, you may proceed.
Miss Garza, how do you know Michael?
He's my fiance.
And where do you live? Do you live here in San Antonio?
Yes,
And who do you live with?
and I'm going to stay with my mom.
Who lives with you?
Me, my mom, and my two stepsons.
So you have two stepsons?
Yeah.
And do you and Michael have any children together, biological?
No, ma'am.
And just what are their ages?
One's 12 and the other one's 8.
And you are the kids were staying with you. Was that due to Michael not being able to live in the home with you and the children?
Yes, ma'am.
And
He wasn't able to stay there.
and is it your understanding that that was a court order when he was sentenced? And you are caring for his children, and do you plan to get married? Do you have a date or?
No, right now I just got the paper for him to sign because he's not able to be there, not be an absent affidavit.
Like a marriage by proxy, or is that what you're talking about? Like getting married without him being present?
Or if it's possible, yeah.
Yeah, just in case whatever the court rules today?
Yes, ma'am.
Okay. And are you asking the judge to continue him on his deferred?
Yes, actually, I am.
And was he a good provider to you and his children?
Yes, he was.
And
What, he's the only provider. Just, I gotta stay at home and I make sure the kids are okay, and make sure they go to school. He's the only one.
and is there anything else that you want the judge to know that you've not already told them?
No. Just, I know that his boy's missing and they want him home.
And his children are present, but not in the courtroom. Is that correct? I'll pass the witness.
Ma'am, I'm sorry, I didn't catch your name. What was that?
Priscilla Garza.
Priscilla Garza. Okay, and so how long have you been in a relationship with the defendant?
9 years.
9 years?
Yes, ma'am.
So you all were in a relationship with each other when this actual deadly weapon occurred?
Yes.
Okay. And so then you all were also in a relationship when he was placed on probation in April of 2025, is that correct?
Yes, ma'am.
Okay. And when he was granted probation, originally, were you aware that he had a condition of an electronic leg monitoring device?
When he was staying at his grandparents, yes.
Okay. And then at some point that GPS device was removed. Are you aware of that?
Yes, his probation officer asked for it to be removed.
Okay. And then after it was removed, were you aware that the probation department never heard from him again? Okay. Was he living with you?
No, he wasn't allowed to stay with me and the boys.
Okay. So where was he living?
But the address at 318 Los Angeles.
Okay. And who else lives at 318 was it right there?
His grandfather, his uncle.
And were you aware that the probation office made multiple field visits to that location? And the people that lived there said that the defendant was no longer living there?
I'm gonna object to hearsay.
Right, that'll be sustained.
Okay. Were you aware that the probation office made multiple visits, field visits to that location?
Your Honor, the fact's not in evidence at this time.
All right, that'll
We're
be,
gonna object and also
that'll
the
be-
hearsay.
that will be overruled.
Were you aware that the probation office made multiple field visits to that location?
No.
And were you aware that the probation office was unable to contact them there at that location?
Well, I
I'm
know he
objecting.
was,
Also,
Right, that'll be overruled.
well, I know most of the time when they did go, he was at work. Cause he did work, cause that was one of his conditions on his probation.
Where was he working?
He was working for a payment company.
Okay. And so I guess you were unable to have contact with him as condition of probation or just?
He would just call and he'll visit the boys, but I know he was supposed to be under supervision to visit the boys, but he never, sometimes he did, but I was there, but sometimes he didn't, because he always worked. He, like I said, he's the main provider for me and his boys. So
And
he's always working.
so correct me if I'm wrong, but the children, they're his biological children, but you're just taking care of them, right?
Yes,
Okay. And you said that he's the only provider, so you don't have anything.
I don't have employees.
Okay. And so if you're asking this court for him to stay on, and he has not been reporting, like, what facts are you relying on to ask the court to continue with him?
Well, the fact is, y'all are asking him to work. So if he's supposed to work and he's not supposed to be there at the house when they go do a field visit or whatever, how is that supposed to even be possible? Because sometimes they do pop-ups and he's at work.
Okay, well, that's why there are multiple conditions in place. So are you aware that he was also supposed to report to the probation office?
And he would,
And a violation that he's pled true to is that he was not reporting
before, when he first got on it, he was reporting.
when
After
he
that,
had the ankle monitor on, correct?
no,
Yes. And once the ankle monitor was removed, he pled true to not reporting to probation.
okay, well, I'm not aware of that because he wasn't staying with me.
Okay, and so you're asking this court, even though you have no facts in how he's performed on probation, you're coming up here and asking this court to continue.
Or he does have two kids that he needs to help me take care of. There's two boys. You try raising two boys on your own. When I'm not the biological mom, I'm the stepmom.
Alright. Don't you think the appropriate time for him to think of his two children was when he was stabbing someone, not when he's on probation?
Can I please leave?
no, dear, you cannot. Your Honor, I believe that that's a harassing question.
Is there a legal objection?
And yes, Your Honor, that it's not relevant or material, and it is harassing
With
the
regards
witness.
to relevancy, the court will sustain the objection.
Cross the witness, yeah.
All right, any further questions?
No further
All right,
questions.
thank you so much for coming in. Call your next witness.
I'll call my client.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Absolutely.
All right, you can lower your hand if you'll state your name for the record.
Michael Anthony Foss.
All right, defense, you may proceed.
Mr. Foz, before you were putting Dawn deferred, you got custody of your children, correct?
Long before,
About a year before,
way more.
2 years before?
than-
Yes.
Yes, ma'am.
Okay, so, your mother of your children had custody, and then CPS got involved, and then you,
I object to leaving.
Sustained.
so, tell me how you got custody of your children.
I got custody of my children, fighting for them for about more than about 8 months. While I was doing federal probation, federal classes, at the same time doing state classes and state UAs, I believe is what they said. And they were coexisting with my federal PO at the same time. And I found, and then the judge who, I believe, I don't know what the proper, for the kids, I guess for CPS, that judge at that time in CPS, the state found fit after all my certificates while I was wrestling with federal probations and state agencies at the same time, while working a full-time job, supporting my kids. That they found that I was fit to be the father, and they found fit to terminate the rights of their biological mother.
And so you have custody, you have your fiance, and how many households were you supporting after you got on this deferred in April of 2025?
Okay, when I moved in with my grandparents and my uncle, my grandfather's house, I'm sorry, my grandmother passed away. When I moved there, of course, I'm not gonna take advantage of my family, so I'm paying rent there, about $450 to $500 a month. I'm still supporting my kids because that was one of the stipulations, support to dependents. So I'm paying about $300, $400 there for them. Then I'm paying my cell phone bill. Then I'm paying UAs when I go take the test. I gotta pay for the parenting class, $85 off the rip. I did 5 out of 10 classes, hostility classes. The only reason I didn't do the other 5, man, I really tried to knock it out. And I realized that we couldn't do the other 5 is because the other 5, they wanted to do them as a one-on-one, I believe it was. And he said he was gonna call me. Like I told him, I had to go to work because all these places, and that's not including my food that I was eating on the day.
Right, so here's the thing. The state recommended that you have deferred. What I want to know is, you pled true to violation of condition number 2. So I wanted to know why you missed drug testing. You pled true to violation for condition number 4. So I want to know why you missed reporting.
Simple fact, miss. I wasn't paying my restitution, what did it constitute, the $4,000 that I had to pay? I'm paying $2,000 when I filed my taxes, and I told Mr.
But what does that mean about the not taking UAs? That's what I'm trying to figure out. Why were you not taking your UAs?
When I stopped reporting, ma'am, I didn't go take the UAs run. Because I was afraid that I was gonna get arrested, because he was getting on my butt about.
Okay, do I not tell everybody if there's an issue with probation? If you have an issue, let probation know about it, and if they're not addressing it, you can come and address it with the court.
See, yes, ma'am, and
So why didn't you do that?
my assuming, it's plain and simple, my stupidity assuming, ma'am, I'm not gonna make an excuse. I assume, because it's never been, this is the only state thing. In federal, when they tell you you don't do it, it's bye. No ifs, ands, or buts, man. And I was scared. And I was just literally trying to buy time to pay this whole freak off. That's it. There's the whole thing off. You know what I mean? I was working and everything. And I did report after the monitor was off. I did do several UAs after the monitor was off.
And so when was the monitor taken off?
Even that gentleman,
No, when was the monitor removed? Does anyone know?
I can tell that, I really don't know, man.
Defense, do you know when the GPS monitor was removed?
I thought it was, it's either August or September.
State, do you know when it was removed? All right, probation, do you?
That was July 9th.
Okay, July 9th. So when it was removed in July 9th, were there any missed appointments, or is the first missed appointment in October? Does anyone know that?
Did UA in September 2025 and thought UA was negative.
The last UA was on 9/19/2025, and it was negative.
So it appears that something happened October and November. So does anyone know what happened with him for October?
Your Honor, I think he was trying to explain that when he would go in, his officer was, according to him, putting pressure on him to pay these fees. And, you know, my client is a very verbal person, and, you know, I think there was not a meeting of the minds that this court would never revoke somebody for monies. We don't have debtor's prison, but he was getting pressure that he had to pay this money, and he's supporting 2 households in and at this time. And he is working. And I want to talk a little bit about work because he had, when one job would stop, he would get another one in between. He's a painter. So if they didn't have a house to paint, he would go and he worked with another person to be working this entire time to support his children and to support these two households. And he does not get subsidy from CPS case. He is the biological dad. He did get custody of his father. And Your Honor, I did go back and look at the sentencing on YouTube, and I couldn't hear everything because I think there was an audio problem. But I think the court had concerns of why he couldn't live with his children. And the concerns were the nature of the offense, and the court wanted to make sure he was not gang affiliated. Those were the two things that the court expressed, say, hey, but we can change that. And you did say that. And according to my client, he is not gang affiliated. They did the gang referral of the gang process.
So you're telling me with the tattoo that he has on the top of his head, that's not gang related? Nobody loves San Antonio that much. I mean, I think San Antonio is a great place to stay, obviously, because I'm here, but usually those are gang affiliations.
But did you do your gang evaluation?
Yes, I did. Yes, ma'am. You ordered it under custody, as a matter of fact.
He had to, and that was correct. He had to stay in custody to do his TAP evaluation, and they were going to do the gang affiliation or
Gang affiliation completed?
Check it out. Pleaded on the 15th of May last year, Judge. Gang affiliation.
And what were the results?
Yeah, they determined there was no affiliation.
That's shocking.
And he did whisper to me that he is in,
They do custody.
so he's not with the gang, with any type of gang in the jail.
All right, State, what are you requesting? All right. This is what the court is going to do. I'm going to give you two choices. There are no other choices. These are your only choices. Do you understand? All right. One, I do note that the state was, not this prosecutor, but the previous prosecutor asked for 4 years deferred. So the court placed you on 5 years deferred adjudication based upon my review of everything. So one, I will revoke you, sentence you to 2 years in the prison. Or two, I'll continue you and you're going to be on GPS until further notice, and it'll be GPS for employment only. Which do you prefer?
Can we step back, Your Honor? Yes. Thank you, Your Honor.
You're welcome. Anyone else who's ready?
Yeah, they're on page, one, second one down, Gabriel Martinez.
All right, and can you let them know that Lord James is here? And I'm sorry, you say which page? I'm sorry.
First page, second one down, Judge.
All right, Gabriel Martinez. Good morning. Let me see where we are here. All right, so I remember we extended the plea deadline date. So
Was for pretrial.
I'm sorry, yeah, PPD was extended.
Yes, ma'am.
So is everything in order with that now?
We filed our application.
Yes, Judge, so they received the application on the fifth and I emailed for an update today and they said they requested a physical file, which is now report the delivery, I'll take it up and they'll process the contract. It's
Okay, I need a PTD date, please.
March 12th.
All right, we'll be back on March 12th.
Your Honor, I have a out of county setting on that date.
Well, what I can tell you with regards to PTD,
We'll probably,
if it's completed, then
we don't show up if it's done.
yes, if it's done. And when I say done, I mean, it's
In the
dismissed.
process.
Yeah.
Yeah.
Okay.
Thanks, Director.
All right, once you sign the reset form, you're excused.
Thank you.
Thank you.
You can have a seat and you can take it too, because it's too crowded at your birthday.
All right, who else is ready?
On page seven, seventh down, Titus Ramirez.
All right, Titus Ramirez.
The attorney's here for Mr. Lloyd as well.
All right,
We'd
and
like
for
to-
something happened at the jail, they took him off.
We'd like to approach, just to talk about a little bit before we
All
move on
right,
that.
just give me one moment. The evaluation can be completed next week.
Yes, yes.
All right, Ms. Ferguson or Mr. Lloyd, if you can recall him in 2 weeks, gonna do an updated evaluation for Mick.
Yes.
They actually,
I don't think it's gonna be Mick.
she's actually does the assessor pointed out that since a lot of his issues are behavioral in custody and he has outbursts, current outbursts when he's brought over, she's recommending state ISF as a matter of fact, and update the TAP.
Well, do we know if there's a mental health issue or we think there is not one?
That's why we think, we don't know, we need to get him evaluated, even if we can go. That's what I'm saying, get the evaluation done, then we can come back and if that's even an option.
What, so we're evaluating him for state ISL?
He says that the cognitive track would be more appropriate because of his outbursts and the things that he's going through at the jail. Because right now he's in a regular unit, he's not in the mental health unit at the jail.
Ah, okay. And it's 2 weeks?
She actually told me she can get him done next week.
All right, Mr. Lloyd, we're gonna bring you back to court in 3 weeks. It may end up being sooner, but they want to evaluate you for state ISF. I'm sorry, for cognitive state ISF. And Norma, if I could have a reset for 3 weeks.
Second, Judge.
All right, if it's completed before then, your attorney will have you brought back before then, but we'll bring you back on March 2nd. All right, thank you, Mr. Lloyd.
Thank you.
Thank you.
Okay.
All right, Arlene, are you ready with your client?
She stepped out, Judge.
Okay.
Go ahead and ask her.
Judge, I'm good to go.
That's for status.
Yes, you're free to go, okay?
You said Tiger was both.
right, we'll bring you back on March 2nd. All right, who's next? Yes.
Well, you did call us.
Oh, yes, we're
already. I
taking,
just-
oh, come forward. What's your client's name?
Titus Ramirez.
And are y'all ready to proceed on the motion?
We are, Judge.
Yeah.
Oh, you. Was it that case? Okay. All right. Sure.
Hello. All right. Court is calling 2023 CR 2781 State versus Titus Ramirez. Can I have parties announced?
James Tochi for Mr. Ramirez, Judge.
And are you Mr. Ramirez? All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Titus Ramirez who was placed on deferred adjudication in 2023 CR 2781 for the offense of failure to stop and render aid on August 28, 2023 for a period of 5 years? All right, state, you may proceed.
Resolution number 2, on or about the 25th day of June 2024 in Bear County, Texas. The defendant Titus Jeremy Ramirez did then and there fail to submit to drug testing as directed by the court, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true? How do you plead to that? True or not true?
Some of it's not true.
Well, the June 24th, I'm sorry, June 2024 date, is that true or not true?
That's true.
Okay.
2, on or about the 24th day of July 2024 in Bear County, Texas, the defendant Titus Jeremy Ramirez did then and there fail to submit to drug testing as directed by the court/supervision officer or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Violated condition number 2, on or about the 30th day of August 2024 in Bear County, Texas, the defendant Titus Jeremy Ramirez did then and there fail to submit to drug testing as directed by the court supervision officer or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
It's true.
The state will waive the remaining.
Any objection?
No, ma'am.
The judge stand by pleading true to 2 and 2. The court could find it true, grant the motion, find you guilty, sentence you up to 5 years in the prison and up to a $5,000 fine. Do you understand that?
That's right.
Knowing that, do you still wish to plead true to 2 and 2?
That's right.
Court will find 2 and 2 true. Is there a proposed agreement?
State is asking that you grant speech motion, enter an adjudication of guilt and sentence to 10 years in prison.
And defense, what are you requesting?
Well, Judge, obviously not that. The recommendation, so the court is aware that is being made by probation is to keep them on probation. They have a slew of treatments that they are recommending to the court. I'd be more in line with that, to include SATF and MRT. Mr. Ramirez, this is not very unique, but he's just one of those guys that, stepped off the line and never, ever found his way back.
So why isn't he taking his drug tests?
I asked him the same thing. What happened? He became homeless. He was checking in for a while. I think he had a good solid beginning to his probation, and then he became homeless. And
Well, I see that this is the first motion to revoke since he was placed on probation in 2023.
it appears that way. And admittedly, on paper, he does not, look like a great candidate. But being homeless, I can't imagine doing anything in life, especially being on probation. He's more stabilized now. Apparently, his parents have accepted him into his home. He tells me that he has been working for the past 8 months. And I asked him, why didn't you come back after that? And of course, it's the trap they all fall in. Once the warrant goes out, they feel like all hope is lost and it doesn't matter. So they just stay away.
All right, any objection to the court reviewing the court summary?
Okay. he would like treatment. I'll let the court read the summary, but he definitely would be interested in residential treatment. He feels it would help him.
All right, this is what the court is going to do. One, I can revoke you and I'll sentence you to 4 years. Or I'll continue you, but you're going to be in inpatient treatment. Which do you prefer?
Inpatient treatment.
All right, the court will deny the motion. Alternate amending conditions to include SATA and portable alcohol monitoring for 1 year. There's to be no driving. There's to be regular random UAs. Field visits 1 time per month until further notice. Probation, the court is recommending SATF. However, I see that he has a TAP evaluation scheduled for February 12th, 2026. If the TAP evaluation recommends something more intensive, then we'll go with the TAP recommendation.
Yes, sir.
If they're just recommending supportive outpatient treatment, we're going to go with SATA. All right. Is there anything else you need from the court?
No,
Probation, is there anything else that's needed? All right, state your excuse. Thank you. Here's the thing. From here on out, everything you do, you need to ask yourself, could this potentially result in me being in prison for 5 years? If the answer is yes, don't do it. And I'm going to tell you what I tell everybody. If there's an issue, let probation know about it. If you feel they're not addressing it, you can come back to the court. Do you understand?
yes, I do. Thank you, Your Honor.
All right, good luck to you.
Thank you.
Are the parties ready on Mr. Foz? All right. We're back on the record in 2025 CR 002639. Which do you prefer?
The 2 years.
Okay. So are you waiving your right to appeal?
Yes.
All right, court is going to grant the motion. Revoke. The court is going to sentence you to 2 years in the prison. You get credit for any time served. There's an affirmative finding of deadly weapon. And there's to be no contact with the complainant. Review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney. Did you understand it? All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. And because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, sir.
Come on this way, Mrs. Fox.
All right, anyone else ready?
Did you count that time? Is that on the counter?
Yeah.
Yes, sir.
Anyone else?
Yes, sir. Page 4, fifth one down, Stephen Nick.
Stephen Yek?
You had to stand.
Court is calling 2025 CR 015674, State versus Stephen Yet. Could I have parties announced?
Brandon Prada for the state.
Danielle Cambrick for the defense, Associate Attorney of Monica Guerrero, the Attorney of Record.
All right. Any objections to proceeding with this attorney, sir? All right. And are you Stephen Yek? How do you pronounce your last name? Okay. Counsel, have you received all discovery?
We have, Your Honor.
Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Did you review the application for deferred adjudication and community supervision with your attorney? Did you understand it?
Yes.
And did you sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We are just.
Sir, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with possession of a controlled substance, penalty group 1, 1 to 4 grams. All right, let's go off the record. All right, anyone else ready?
Second, third, and check the paper. Where's that? Page, 3, third one down, Rodriguez.
Enrique Rodriguez? All right, that's Mr. Chumbley.
Oh, yes.
Hi. That's okay.
Multitasking.
Oh, that's okay. And counsel, you're on this side.
That's right.
All right, so.
Okay. I met with my client last week and we got an offer. There's some discovery that I'd like to verify that I've got everything. There's some videos that are pretty important on the case. I don't need a bunch of time, you know, maybe 3 weeks or 2 weeks, something like that.
All right, Ms. Ferguson, can you recall this in 2 weeks, please?
Oh, I would really like to settle this today.
Oh, you'll need to speak to your attorney.
Okay. All right. Well, that's different from last week. So.
Okay.
Okay. All right. Thank you.
You're welcome.
So no date right now, just.
No date right now.
Okay.
All right, who's next?
1 second, Joseph, signing in. Do you have the start of appeal? Sir,
It's a reference.
do you have the start of appeal?
Pardon?
Do you have,
An MTR.
do you have the start of appeal?
Yeah. Pardon?
Yeah.
Probably not.
They're on the.
Okay, all right. That what it means? Okay. A 5,500. That's the MPR. And PRC block. You got it on there somewhere? Where's the NPR? This is this. Your partner's. I might have it for the quick. John, you need to factualize. Because once it's not good enough. What? Make it matter, right? Okay, thank you.
All right, thank you.
That one is on page 7, first one.
All right, who's here for Starbright? Are you all ready? All right, thank you.
Sorry about that.
All right, thank you. All right, the court is calling 2024 CR 007825, State versus Starbright. Could I have parties approach and announce for the record?
Right, safe. But written out for the defense.
It's two cases. Two cases.
All right. One moment. And are you Starbright? Did you review the document entitled motion to enter adjudication of guilt and revoke community supervision and First Amendment motion to revoke community supervision with your attorney? Did you understand it? Yes. Are you the same Starbright who was placed on deferred adjudication in 2024 CR 007825 for the offense of possession of controlled substance penalty group 1 to 4 grams on September 17, 2024 for a term of 8 years? Is that you? All right, state.
Judge will be proceeding on a violation condition number 2, specifically that on or about the 20th day of August 2025 in Bexar County, Texas, the defendant, Star Crystal Bright, did then and there illegally use a controlled substance, namely amphetamines, in violation of condition number 2.
How do you plead to that? True or not true?
The judge will waive and abandon the remaining allegations.
Any objections?
No objection, Judge.
Did you understand by pleading true to violation of condition number 2, the court could find you guilty, grant the motion, sentence you up to 10 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. State, what are you recommending?
Judge will be recommending to waive and amend to DDRF. This is a probation's recommendation. The defendant's picked up a new drug case and are pretty much needs inpatient treatment. The DDRF will provide.
And defense, what are you requesting?
Judge, we're asking obviously something different. We're asking that she be continued on deferred. She had, and be given outpatient treatment. The allegations are that she was scheduled for outpatient treatment before, failed to make 2 intakes, but was doing a different program, was not able to provide proof, but that was not disapproved by the probation officer.
Mhm.
She wants an opportunity to show the court that she can do an outpatient treatment. She has 3 grandchildren. Her daughter needs help, 2 to 13. She has mental health issues. We're going to ask that she be managed by the MEC, supervised by the MEC. She understands she has a problem. She wants help with that problem. She was trying to get help herself. She's just has some problems herself getting that done. She believes that she can do an outpatient treatment and help her daughter take care of her kids. That'll give her some stability, if you will. I think it would give her frankly, would give her an opportunity as well to build some self-confidence that she can do something with her family, useful, and for herself. She's willing to do that. She knows she needs help. She does have her mental health issues, primarily diagnosis and anxiety. That gets in the way of getting some things done on her own. With MEC supervision and her agreement to do an outpatient, whatever the probation says, outpatient treatment, she believes she can get this thing completed.
All right. So probation, I had previously recommended felony drug court for her. Was she ever interviewed by them?
She was not eligible, Judge.
All right,
According
and,
to
all
the
I don't have
report.
the copy on the.
right, and do we know why she wasn't eligible?
It doesn't say on
It
here
just
why.
does not eligible.
Yeah, it just says it does not qualify for court summary, Judge. Doesn't give a reason, unfortunately.
All right, so here's the thing. I think you need a form of inpatient treatment. I don't know if DDRF is appropriate or not. Probation, will DDRF address any drug issues or just mental health issues?
It will address both, Judge.
But the wait time is long, correct?
Yes, sir.
Yeah.
All right, this is what the court is going to do. The court is going to deny the motion. Alternate amend conditions. And what I'm going to want is I'm going to run a this is going to take place in custody. Counsel, I'm going to ask for a re-referral to felony drug court. And if maybe you can talk to them, because they do have a dual diagnosis program. And they'll
Right.
make the determination of whether inpatient treatment or outpatient treatment is appropriate for you. And if not accepted, will SafeP address mental health issues?
Under the cognitive tract.
All right. So if not accepted to that, then it will be SafeP. What I'm going to tell you is the wait time to DDRF is, how long is it? 13 months, 20 months,
It's about 4 to 6 months.
4 to 6 months. So court would deny the motion, alternate amend conditions for the following, and this is to take place in custody. There's to be a re-referral to felony drug court. Defense, you'll talk to them, see if they'll accept her. And if not accepted, then SafeP. Is there anything else?
I'll contact the drug court.
And probation,
Yes, sir.
there is to be no unsupervised contact with minors. I'm sorry, what?
That would not let her take care of her grandkids.
I mean, she's not in any position to be doing that right now. Of course, you know, that will change once if she's accepted in felony drug court will make that decision. If she's not accepted in felony drug court and she goes to SafeP, then she can always come back here and I'll reconsider it. But I can't in good conscience allow her to do that if she is not clean and sober and on, you know.
So we
a
can
good track.
readdress it as
Yes.
appropriate. Right. All right.
Thank you.
Okay.
All right, the parties on Stephen Yick. We're back on the record in 2025 CR 015674. Did you review the document entitled Court Admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
All right. By indictment, you're charged with possession of controlled substance, penalty group 1 to 4 grams. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, is there an application for deferred adjudication or no?
It should just be for community supervision, Your Honor.
All right. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering into this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 4 years in the prison. There's $1,000 fine that will be probated, and the state recommends community supervision. Did you understand that as your plea? Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, there being such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There be 100 hours community service restitution, the DOEP course, the MRT, and regular UAs. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Judge, we offer say exhibit number 1 and all of its attachments.
No objection, Your Honor.
All right, state, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Please, Your Honor.
Anything you wish to say on behalf of your client?
We would just ask the court to follow the agreement.
All right. So when's the last time you had employment?
12 months ago.
And what is your employment?
Then a factory.
So how often have you been using?
In about a month.
So here's the thing. I need you to be honest with me because I'm trying to set conditions that will help you, okay? So do you have a support system? And who is your support system?
My parents got separated, so they moved back to the city of Philadelphia.
Mhm.
They support me there.
All right. Are you asking that your probation be transferred to Pennsylvania? All right. Do you know what county that is?
Philadelphia.
I'm sorry?
Philadelphia.
So it's Philadelphia County?
Yeah.
I'm sorry?
I have to double check, but it's not 100% sure.
But it's Philadelphia, Pennsylvania.
Yes.
Okay.
I have to contact them first.
Okay. And do you have any children?
No.
All right, this is what the court is going to do. Court is finding you guilty. The court will sentence you to 4 years in the prison, suspended and probated for 3 years. There's to be regular random UAs, regular reporting by Zoom or in person. There's to be a transfer to Philadelphia, Pennsylvania. You're not transferred to Philadelphia until you receive approval. So until you receive approval, you'll have to remain in Bexar County. Do you understand?
They're not gonna approve it. They won't approve it.
Why not?
I don't have I have a phone number, but it's they won't answer the call.
Well, here's the thing. You're telling me that you want your probation transferred to Philadelphia. So I'm going to ask probation to do what they need to do to see about transferring it to Philadelphia.
I can get it. Yeah. And I stay here in Bexar County.
So you don't want to transfer it to Philadelphia? All right, so there's no transfer to Philadelphia. There's to be proof of employment within 40 days of release. There's to be no employment as a home health care provider or with minors. There's to be no residing in households with minors. There's $1,000 fine that will be probated. 200 hours of community service restitution. I'll deduct an hour for every sober support meeting that's completed. I'm going to want field visits 1 time per month until further notice. TAP evaluation in custody. Follow recommendations. Probation, is there anything else?
I just wanted to advise the court that he is listed on his data sheet that he is homeless with no phone. So he has no address.
All right, so probation, you'll need to work on housing for him. So probation will work on housing for you. It will most likely be Haven for Hope.
Okay.
Thank you, Judge. So with regards to that, probation will provide any resources. Is there anything else you need from the court to be successful?
No, Max.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, miss.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney, okay? All right, we can go off the record. Here's the thing. In this court, to be successful, communication is key. If there is an issue, don't just disappear. Let probation know about it. If you feel they're not addressing it, you can come back and address it with me, all right? All right, thank you. Thank you, Judge. Thank you. Anyone else ready? Leanne Garcia.
Gonna be on page 2 at the bottom, Judge.
Stop behind you. Straight ahead into the tree box from the.
Morning.
Good morning. Hello. All right, the court is calling 2025 CR 013410 State versus Leanne Garcia. Can I have parties announced? For the state,
Galloway for state.
Dwight Chumley for the defendant. Your Honor.
and are you Miss Garcia? Counsel, have you received all discovery? Did you review it with your client?
Yes,
Court will find that the state is in compliance with discovery. Are there any applications?
no, Your Honor.
Ms. Garcia, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes,
State, are you proceeding on the indictment as presented? Ms. Garcia, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Your charge is possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
she has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe so.
Ms. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Do you understand? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 6 months in the Bexar County Jail under 1244. There's an $800 fine and there are no applications. They will take in consideration 2026 PF 01338. Did you understand that to be the plea? Defense?
Yes,
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No,
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Whoever states one in a fact.
no objection.
State you may be excused. Oh, do you all? Thank you. Did you review the waiver and stipulations with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
No, Your Honor, we'd just like you to follow the plea bargain.
All right. Court will follow your agreement. The court will sentence you to 6 months in the Bexar County Jail under 1244. Give you credit for any time served. There's an $800 fine, time and money to run concurrently. And the court will take in consideration 2026 PF 01338. Is there anything else with regards to sentencing?
No, Your Honor.
Okay. Did you review the waiver of appeal? I'm sorry, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Is this anticipation of a judgment satisfied or no?
Not yet. What, 40 days? 60 days.
All right, so here's the thing about that. Sometimes when you're in general population, for every day you're in there, you get 2 days credit. I'm not in charge of whether you get 2 days credit or 3 days credit. That's something that the Bexar County Jail does. So I have no jurisdiction. If you think you should get 2 for 1, I have no jurisdiction to force them to give it to you. All I can tell you is under my sentence, the most you will have is 6 months, and I've given you credit for any time that you've been in custody. Now, the other thing, it appears you may have some substance abuse issues. When you're released from jail, you need to get help. If for some reason you can't find help, if I'm still here, you come back here, I will pick up the phone, call somebody to find a place for you, because no good can come of it. You understand? All right, good luck to you, okay?
Thank you.
You're welcome. Yeah. Who's next?
Page 2, fourth one down.
Carlos Gonzalez? Yes. Good morning. How's it going? How's everything been going?
It's been kind of tough,
I'm sorry to hear
but
that.
we're doing a lot better now. We've post-surgery is pretty healed and, you know, but she's still a little sore from the walking. She's getting her therapy and everything and whatever.
That's good.
So we kind of survived. And then I got the flu. She got the flu.
That's been going around.
Right.
All right, so on this case, what is happening?
Judge, on this case, I've been discussing plea agreements and things that have been offered on this case to my client. However, he is not in agreement with any of them and desires to have the court appoint him another lawyer.
Okay.
So we're asking for a divorce.
Oh, yeah, we don't need a divorce, but I'm sure.
The reason I'm asking for divorce, I don't feel that this lawyer has my best interest. Right now, I was talking to him, and because I didn't accept the plea that he gave me my first things, called me hard-headed and stuff and some other stuff, but that's one of the reasons why I want a lawyer. It doesn't, not because of what he just said.
All right, so this is what I can tell you. I've been a defense attorney, right? Sometimes people may have what's called a good bedside manner, sometimes they don't. What I can tell you is defense attorneys, they can't force the state to tender an offer that somebody wants. legally and ethically, the only thing that's required when it comes to offers, if an offer is tendered to them, they're required to let you know what the offer is. Now, when that offer is tendered to you, you have a choice. You can reject it, which means you're saying like, no, I'm not accepting that. Or you can do what's called a counter offer. With a counter offer, you tell your attorney, I want to accept this, but this is what I'm willing to accept. And then legally and ethically, your attorney must go back to the state and say, my client is rejecting your offer, but this is the counter offer. And then the state can either accept your counter offer or reject it, or they can come back to you with something other than their first offer. But that's completely up to them. So your only choices today is if you all have an agreement, the court is willing to go forward with that. Otherwise, this needs to be set for a jury trial.
That's what I asked for, Your Honor, and he's,
Right.
he doesn't want to take this trial.
No, here's the
I never
thing.
said that. He's calling me hard-headed.
I just said, if you want a trial, we'll give you one.
Oh, yeah, well, we're gonna give you a trial. Ms. Ferguson? Set this for trial. Okay, what date? All right, we'll be back on the 17th, and that will be your jury trial date. Once you sign the reset form, you're excused.
Thank you, Judge.
Thank you. And counsel, let me see. Can you make sure an acknowledgement of discovery is completed, please?
Judge, I'm sorry.
All right, thank you.
There's one in the file. I'll get it done for
All right, thank you. Thank you. All right, Summer Muniz.
Ready, Your Honor.
Hello.
Thank you.
Court is calling 2026 CR 0000686 State versus Summer Muniz. Could I have parties announced?
State.
James Seeloff for the defense.
And are you Ms. Muniz? Counsel, have you received all discovery? Did you review it with your client?
Yes, I have, and I have.
Court will find that the state is in compliance with discovery. Ms. Muniz, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do on all the cases.
Thank you. State, are you proceeding on the indictment as presented?
We are, Judge.
Ms. Muniz, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
By indictment, you're charged with fraudulent use or possession of identifying information less than 5 items. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea, gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, she has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she was.
Ms. Munoz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported and denied re-entry. Did you understand?
Yes, ma'am.
And also denied naturalization. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she was.
Ms. Munoz, has anyone threatened you, coerced you, or placed you in fear to get you to? I'm sorry, I already
You're
done
doing it
that.
twice.
I'm doing it twice.
I like your voice, so I just listen.
You just went along with it. Okay.
Yes, ma'am.
Did you review the plea? The court will find that the defendant has knowingly and voluntarily waived her right to jury trial. That's what happens when I'm trying to multitask. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
All right, so everything, the plea bargain agreement that I previously stated, do you understand that to be your plea?
Yes, ma'am.
Defense,
Yes.
state.
It is, Judge.
And did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
All right, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No motions, Your Honor.
Outside the agreement, the state is asking that you have no contact with the complainant and no contact with Fox Rental Car. Did you understand that?
Yes, ma'am.
That's a recommendation from the state and the court does not have to follow that recommendation. Did you understand?
Yes, ma'am.
Then to the offense, how do you plea? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Judge, we offer state exam number 1 and all attachments.
No objection.
All right, did you review the waiver and stipulations with your attorney?
Yes.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
So,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, we are.
Anything you wish to say on behalf of your client?
We have worked out a pretty nice deal with the prosecutor on this, and we asked the court to follow. She's 29 years old and needs another break, one break. And she's gonna go to the TDC for 6 years, so that's where she's gonna learn.
All right, the court is going to sentence you to 2 years in the state jail facility, give you credit for any time served. There's a $1,200 fine, time and money will run concurrent. This will run concurrent with 2022 CR 2906. And there's to be no contact with Fox Rent a Car. Do you understand?
Yes, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes,
Did you understand it and sign it?
yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Next, we're proceeding in 2023 CR 2906. Did you review the document entitled Motion to enter adjudication of guilt and revoke community supervision, and First Amendment motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes.
Are you the same Summer Muniz who was placed on deferred adjudication in 2023 CR 2906 for the offense of tampering with a government record on May 15, 2023 for a period of 6 years? Is that you?
Yes, ma'am.
All right, state, you may proceed.
Yes, Judge. Well, you will be proceeding on violation of Division 1, specifically the on or about 3rd day of January 2026, from Berry County, Texas. The defendant, Summer Muniz, committed the offense of fraud and violation of condition number 1.
How do you plead to that? True or not true?
True.
State,
The judge will be waiving the remainder of the allegations.
any objections?
No objection, Your Honor. That's our understanding.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 1? Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Judge. Following the defendant's repeated violations of the rules of safety and being kicked out of felony drug court, we don't believe she's recommended for probation. The agreed amount is 6 years to do in the Texas Department of Corrections.
Yes, and we're asking for the court to give her full credit for time served, including her safety time. Thank you. That's our understanding.
All right, are you asking the court to follow the agreement that you reached with the state? Are you waiving your right to appeal? All right, so here's the question for the court. Was Safe P successfully completed or no?
I don't believe it was.
Was it?
Yes, it was
It was?
successfully discharged. I have my certificates.
Okay.
I know they didn't get an extension.
All right, this is what the court is going to do. The court will find you guilty, revoke, sentence you to 6 years in the prison, give you credit for any time served. and they'll make a determination on whether or not you successfully completed inpatient treatment or not. But the court will give you credit for any successful completion of inpatient treatment. Legally, that's required. The court will recommend the therapeutic community. Is there anything else with regards to sentencing?
Nothing, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing, if you don't change the way things are going for you, only two things going to end up happening. Either you're going to end up spending the rest of your life in prison, or the last time you use may be the last time you use. How are you? How old are you? All right, so you have a lot of your life in front of you. But, you know, I have a friend who went through what you're going through. They're doing great now, but now guess what? They have to take extra care of their body because they said they just put their body through the ringer by doing all of these things, because there's a lot of health issues that comes with that. And so you're going to have to get it together. When you're released from prison, if you can't find a place to help you on your road to sobriety, come back here. If I'm still here, I'll help you, okay? All right, good luck to you.
Thank you, Judge.
You're welcome.
As long as we're still off the record.
Mhm.
If. Thank
Okay.
you very much. May I
You're
be
welcome.
excused?
Yes.
Swear in on the clean and all
Good luck.
paperwork.
Oh, just 1 second. You have this, just
Wait a
1
minute,
second
ma'am.
with her.
Yeah. Thank you very much, Judge. This is dismissing those other people.
Okay. Thank you.
Nick.
There you go.
Yeah. See where they're.
I just sent you an email on that's on here. I sent the trial on March. We want to have, I just prefer to say it on a pre-trial motion here. Take like 15.
All right, thank you.
Yeah, I sent it. I literally sent it.
Jeremiah Mark. Fabian Singh.
Hold on, all here, the 15.
Alfred Areola. Thank you. David Cortez Jimenez. All right, for those of you who are on bond, if your attorney hasn't shown up, you need to step outside and call them. Otherwise, you're going to be recalled for the afternoon. All right, Matthew Cadena. I don't know.
stepped out of call. the
Ah.
attorney.
Could you make an announcement for Matthew Christopher Cadena to come back inside the courtroom? Thank you. Mhm.
And then I have another thing. On the last page.
All right, let me do this first.
I should get in a minute.
All right, if you come forward, please. All right, we're gonna reset your case for the end of February. Your attorney is out, okay?
Okay.
All right, Ms. Ferguson, I need a date for him at the end of February.
I think it's 26, so
All right, so we'll come back on February 26th. And are you employed? All right, so I'll allow you to appear by Zoom.
Okay.
Because the issue is for discovery.
Understood.
All right, so Ms. Ferguson will give you the reset form. Once you sign that, you're excused. And Norma, if you can put on there that he can appear by Zoom. All right, and I just received this email. Okay, you're welcome. And Norma, that's still a discovery setting.
Yep. Guess I'm preparing a plea.
All right. And who's here on Enrique Rodriguez? All right, we're ready. Hello. All right, the court is calling 2025 CR 014-634 State versus Enrique Rodriguez. Could I have parties announced for the record?
White Chumley for the defendant.
And are you Mr. Rodriguez?
Yes, ma'am.
All right, counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Enriquez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
No, Your Honor. Oh, yes, I do. Your Honor.
Okay, no problem.
I just felt like saying no.
State, are you proceeding on the indictment as presented? Any objections to the waiver?
No, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right, you're charged with theft of property, $2,500, less than $30,000. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Okay. Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe so. Yes,
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
All right, sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 18 months in the state jail facility. There's a $2,000 fine and no applications. Did you understand that to be the plea? Defense?
Yes,
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, any such motions?
no, ma'am.
Then to the offense, how do you plead? Guilty, not guilty, or no contest? State any evidence? Any objections?
Objection.
All right, state your excuse. Did you review the waiver and stipulations with your attorney? Did you understand it and cite it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witness statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, my client and I have discussed this case. He has remorse and he's sorry and he understands seriousness of what he did, and we'd like you to file the plea bargain.
Okay. All right, the court will sentence you to 18 months in the state jail facility, give you credit for any time served. There's a $2,000 fine, time and money to run concurrently. There's to be no contact with Luis Morales III and Yvonne Costrita. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. You're going to get to a point where these cases are going to start adding up, time is going to start adding up, and you're going to see your life passing you by. If you continue like this, you're going to end up spending the majority of your life in prison or in custody somewhere. You understand? Your attorney will tell you at some point these state jail felonies become habitual, in which case it becomes a second-degree felony, 2 to 20 years. And you have to ask yourself, taking this vehicle, is that worth 18 months of your life? Whenever you're thinking about stealing, because I see your history, you need to ask yourself, is this worth 18 months of my life? Is it worth 20? If there's a drug or alcohol issue that's causing this, when you're released from custody, if I'm still here, you come back here, I'll pick up the phone, and call somebody who can help you, okay? All right, you're welcome. Good luck to you.
Thank you, ma'am.
You're welcome. All right, who else? All right, Robert Ortiz.
Right, page 1, first one, good.
Okay. All right, the court is calling 2024 CR 009791, State versus Robert Ortiz.
Can I tell you before we get started, he's a little bit hard of hearing, so if you could really project and speak a little bit slowly.
All right, thank you. All right, could I have parties announce?
Brandon Bray for the state.
David Rodriguez for the defendant.
And are you Mr. Ortiz?
Yes, ma'am.
Counsel, have you received all discovery and reviewed it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ortiz, did you review the true bill of indictment with your attorney?
Yes,
Did you understand it?
yes,
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yeah.
Mr. Ortiz, did you review the court admonishments with your attorney?
Yes.
Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes.
All right, you're charged with theft of property, $2,500, less than $2,500, with 2 or more previous convictions. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, I do not have to follow your plea. If I do not follow your plea and give you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Do you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yeah.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Ortiz, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yeah.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 180 days in the state jail facility. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
It is, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yeah.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Then how do you plead to the offense charge? Guilty, not guilty, or no contest?
No.
No contest? Is that your plea?
Yeah, no.
All right. State any evidence?
Judge, we have to say exhibit number 1 and all the steps.
No objections.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yeah.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yeah.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments. Court has reviewed the same. The court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Just I would urge the court to follow the plea bargain that we've reached.
All right, the court will sentence you to 180 days in the state jail facility, give you credit for any time served. There's to be no contact with Walmart. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yeah.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, so we can go off the record. You're gonna have to start doing things differently. If there's an issue with not being able to afford certain things that are necessities, there's the Salvation Army, there's the food bank, there are other places that can help you. You understand? All right, good luck to you. Thank you, counsel.
Thank you, Judge.
Norma, what other emails do you have?
It was just a phone call. I just want to take over. Working on another feature.
All right, state on Mr. Jones, the attorney informed Norma they have the flu. Do y'all have witnesses here? Because it was supposed to be, I think, a motion to suppress. So if you do, you can't. Brenda, yes.
Brandon?
Yes.
Talk to Brandon.
No, has the flu. He's not gonna be here. Yeah, yes. So I need to know when you all will have witnesses. You need to speak with Ms. Ferguson.
Got it.
On a date. Mr. Jones? Betty Jones? Hi, your attorney has the flu, so we're gonna give you a reset, okay? All right, just have a seat and we'll be with you.
Can we talk to you about the Jones, the MTS? I'm just out. Okay, 22nd.
All right, Norma, what date?
February 23rd.
All right, yes, and if you'll give the Mr. Jones a reset. Good morning. All right, no problem.
Mr. Jones, come up here, sir.
I thought I had a guy named Sam that's in the docket. And I filed.
On page 4.
Do you have a partner in the back? Do you have someone in the back? Okay.
Grab a pen from there, sir, see if you can sign.
Probation? Go. Thank you. Yeah, anyone else ready?
Yes, that's page 1.
Thank you.
Enrique Lopez.
Enrique Lopez? Hi,
How you doing?
I'm doing great. How are you doing?
Oh, I can't complain. Another beautiful day.
All right. So what is happening? Are we going to jury trial on this case? What's going on?
Your Honor, we're asking for a short reset, like 2 weeks, so my client can think about the new offer. I don't believe it's gonna go to jury trial. I think we're gonna get it resolved.
All right, so here's the thing. This was set since October for November 6th for disposition. So either we're going to jury, either you're going to be brought back tomorrow, dressed for trial, or either something's going to work out today. So
I was never called that, except on November 6th.
no, I gave you all a disposition date for November 6th. So this has been waiting for you all to make a decision on an agreement or not since November 6th. Well, really since October 27th of 2025. So either y'all have an agreement or you don't. If you don't, then you'll be brought over dressed for trial for tomorrow.
I think this is our second court setting, Your Honor. I don't think we were ever called in November.
No, I mean, you all had a date. Am I wrong about the date? Is there something it can happen. Is
I'm
there
not sure.
something in the court summary that is incorrect? I mean, it's been known to happen with Odyssey.
Yeah, from my recollection, Your Honor, well, I was trying to look it up on Odyssey, but I couldn't really tell. But this is our second setting on this.
Mhm. Yeah, no, there was disposition that was given, a setting was given in October, according to the system, October 27th. And we were supposed to come back on November 6th, and November 6th was a plea deadline hearing.
We never came
And-
back on November.
Yeah, I
6th.
know. So you guys have had though, since October 27th, unless the state offered you all something new.
It is a new offer, Your Honor.
All right, Ms. Ferguson, on this case, recall this for tomorrow. So we'll see y'all tomorrow. Either it's gonna be trial or either you all will have come to an agreement.
Okay.
All
Thank you,
right,
Your Honor.
Deputy Laura, Mr. Lopez needs to be dressed for trial for tomorrow. All right, who else?
Second judge. On page 8 and on page 1, Brandon Castle. And I want to end here.
Okay. Oh, okay. So are they ready on the motion to revoke or no?
Alderman Bunkers. Calling your.
McCaskill, are y'all still conferring?
We're conferring, yes, and if we're not able to reach a resolution, then I'd like to be heard on those process.
Okay, thank you. All right, anyone else ready?
Page 2, verse 3, Martinez.
Jesse Martinez.
We're good.
Good morning, how's it going?
All right, good to see you.
Good
I was
to see you
excited.
too.
They said, what do you got going on? I said, I'm gonna go see Judge Boyd this morning. I
Oh,
said, tried to see you last week, but you're in a jury trial. So-
all right, so we're just here today for discovery.
He just got indicted and served this morning, Judge. They just uploaded a new batch of discovery, which I'm downloading
Okay.
today. So
So based upon the offense, what we're gonna do is we're gonna set it for 45 days because I know it's a lot of discovery.
it is, Judge. There's about 8 videos that we're trying to get downloaded. Plus I have to go visit with them for other videos that
Okay.
they can't produce.
All right, so we're gonna set it for 45 days to see where we are on discovery.
Yes, sir.
Yes, Your Honor. Thank you. March 26th. Thank you, Judge.
All right, we'll be back on March 26th. It's just to make sure that your attorney has all the discovery. And is there anything that I need to sign, any orders?
No.
No. I filed some pretrial motions, Judge, but again, I think most of those are going to be agreed to.
No, I mean, any other orders, protective orders?
Oh,
CPS record, Your Honor, I do believe we had one already.
I thought we already had signed, Judge, too, unless,
Oh, okay.
unless I need to do another one.
All righty. Well, if that's been signed, then we don't need to
And
do
those
another
records
one.
were being produced today, so I think
Okay.
we should be okay.
All righty.
I'll come by and see you as soon as they get all the records in. Okay.
All right, thank you.
Thank you, Judge. May I be excused?
Yes.
There's you also have Julie on the back. Brandon Lopez. No.
Okay, who?
Sunika, and you got page 8, just do that.
All right, just give me a moment. All right, what page did y'all say he was on?
Here's on page 8, Judge.
Oh, see, y'all were pronouncing it and it sounded like it was a Z instead of a S.
Yeah.
All right, Deputy Laura, can you have him brought out?
In the back, Judge, I'll have to wait for someone.
Okay, all right, thank you.
Oh.
Yes.
Just in an abundance of caution.
Yeah. Yeah,
Thank you, Judge.
you're welcome.
Judge, I'm preparing a plea.
All right, thank you.
Judge.
All right, Mr. Suniga, if you'll come forward, please. Hi. Hi, your attorney is out with the flu. So we're gonna have to recall your case, okay? All right, so Norma, can you recall him in 14 days?
You want me to give him the same date, the 23rd, Judge, like the other one?
Yes.
It'll be February 23rd.
So we'll bring you back on February 23rd. Do you have any questions?
Yeah,
All right, so we'll bring you back then, okay? Thank you.
Yeah, you're ready, Judge. I have some.
Okay. Just one moment. Okay, I am ready.
The reference on page 1, 5 down, equals the line.
You say Denise Lujan? Good morning. All right, so hello. So on this case, where are we on discovery?
I think we're good on discovery, Judge.
Okay, and has an offer been tendered?
Good trial. She would like a jury trial.
Okay. All right. How long do y'all expect this trial to last?
3 days at the most.
All right, Ms. Ferguson. They're requesting a jury trial. Can you recall this for tomorrow? All right, we'll see you back tomorrow for jury trial. Once you sign the reset form, you're excused. And could y'all make sure that I have a acknowledgement of discovery, please? All right.
But it's on page 7.
All right. So on Fleming, we're going to recall this. Let me see.
Is a site eval?
No, they completed it.
Mr. Fleming?
And so,
Oh, here it is.
yeah. So the magistrate's court will have to see what's appropriate. So, sir, what's going to end up happening is this case is going to be sent to the magistrate's court to handle the issues that are been brought to my attention.
What issues?
I'll let your attorney explain it to you, okay? All right. So, counsel, I'm going to set it for 60 days in this court,
Okay.
but the magistrate's court will have a different setting for you. And what I can tell you, the magistrate's court setting will be much sooner than this one, okay? So you'll have two courts that you appear in. You're going to appear in magistrate's court and you'll appear here, all right?
Why is it?
Okay. Yeah, he'll explain it to you, okay? All right, Ms. Ferguson. All right, so we'll put it for April 13th, but counsel, if they're still trying to address the issues that have come up, just let us know and we'll set it on another day.
Will do. So I guess I should get with Matt, get it.
Yes. Yeah. All right, who else?
Alfred, are you? It's on page 4.
Alfred Ariola. So why were you late for court?
Today, I didn't have a vehicle, ma'am, because of like, they took away my vehicle.
All right,
That's
so,
why I had to call somebody to try to get me in this, I don't have any answers, so I can.
so here's the thing. That's where the VIA bus comes in.
Siblings, yeah, I get it, I never, I'm not from here, so I just moved to.
right. So you know, here's the thing. When I first came to San Antonio, I had to ride the bus. When I was attorney, I rode the bus. And guess what I would have to do? I had to figure it out. And you know what my mom told me? Stephanie, when you get on a bus, just ask the bus driver, tell the bus driver, this is where I need to be. Am I on the right bus? And they'll let you know. And you're going to have to take the early bus to make sure you're on time. So I would end up arriving at the courthouse at 7:30 a.m., even though people's dockets didn't start till 9, because I had to make sure I'm on time, okay?
That's my fault, I apologize.
All right. No, I'm just letting you know, okay? So don't be late anymore because this is the second time you've been late for this court.
Yes.
All right. So counsel, where are we on discovery?
Judge, Mr. Ariola has a DWI case pending also. We don't have the results back on that, so we're trying to coordinate both of these cases, so we'd like a little more time to get the results back on the DWI.
All right. So Ms. Ferguson, on this one, are you able to put it on the April the 13th date too? All right, April 13th.
Thank you, Judge.
All right, thank you.
Wait for me.
For discovery, correct?
Yes. Brian Berry. Hello.
Well,
All right, the court is calling 2025 CR 015568 State versus Brian Berry. Can I have parties announced?
State.
Matthew Brown for the defense.
And are you Mr. Berry?
yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Berry, did you review the application for community supervision with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge, as presented.
All right. Did you review the court admonishments with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am, I did.
All right. You're charged with criminal mischief, $2,500 to $30,000 as a habitual. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Berry, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 5 years in the prison. There's $1,000 fine. The state is asking for restitution to the complainant in the amount of $500, and they're recommending community supervision. Did you understand that to be your plea?
Yeah.
Defense, is that the plea?
Your Honor, it is. I believe the fine was to be probated.
Oh, I'm sorry. Yes, probated. All right, defense, is that the plea?
Yes, Your Honor.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be 100 hours community service restitution, no contact with the complainant or CVS pharmacy at Southwest Military Drive, and the MRT. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am, I understand.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
I plead not guilty, ma'am. I mean, not guilty, ma'am, I'm sorry. I plead guilty.
And to the enhancements, how do you plead? True or not true?
True.
State any evidence.
Judge, you have 1601 and all attachments.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am, I did.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, the court will find there's sufficient evidence to find you guilty. The court will find the enhancements true based upon your plea are true and based upon states exhibits 1 and attachment. So does anyone want to tell me why I should follow this agreement?
Judge,
I said, why should I follow this agreement?
Judge, it's the wishes of the complaining witness that she paid back her deductible $500. To my understanding, any kind of TDC offer would preclude payment of restitution.
No, he'll still be paid for restitution. I don't understand why I should follow this plea because I'm reading the police report and I read the police report. It seems like there was just a random, let me destroy her vehicle. So I don't understand why I should follow this agreement. I'm trying to figure out why.
Judge, I believe that Mr. Berry wants you to follow it because it's in his best interest due to the fact that he's a habitual offender. It would be in his interest to have the court follow this agreement rather than proceed where he would be open to a much larger sentence as a habitual offender.
All right, so I don't think he's appropriate for probation.
Can I step back, Judge?
Yes. All right, anyone else? Want?
There.
All right, who's here on Sebastian Gabriel?
Oh, that's me.
Oh, I'm sorry.
That's mine.
Oh, you have a question?
No, that's mine. That's mine.
Oh, okay. Oh, let me let you do that. Then we'll come up with that.
Yeah, if we could proceed on Sebastian Gabriel first. We've conferred, Judge, but
Okay, thank
it
you.
might take a minute.
Sebastian Gabriel. Court is calling 2025 CR 014814 State versus Sebastian Gabriel. Could I have parties announced?
Ready for the state?
Matthew Brown for the defense.
And are you Mr. Gabriel? So have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Gabriel, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, I believe we're waiving the punishment enhancement for all proceedings charged.
Any objection?
No, Your Honor.
Mr. Gabriel, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right, you're charged with tampering with the electronic monitoring device, intensive supervision as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you intend to give up your rights to a jury trial and the right to remain silent? And the right to cross-examine any witnesses the state will call?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Gabriel, has anyone threatened you, coerced you, or placed you in fear to get you in the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? I'm sorry, that's the incorrect question. Did you understand if you're not a U.S. citizen, by entering this plea, you will be denied naturalization and re-entry into the United States? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? All right, according to your plea, punishment is to be assessed at 2 years in the prison. The state will run this concurrent with 23 JUV 00249B. They're taking in consideration 2026 AL 000120, 2026 AL 000122, 2026 AL 00123. Did you understand that to be the plea? Defense, is that the plea?
It is, Your Honor. I think on that last one, it was 000123.
All right, thank you. You're correct. It's 3 zeros, 1, 2, 3. State, is that the plea? Did you understand that to be the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counselor, have there been any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Judge, you have to say exhibit number 1 and all attached.
No objection.
All right, state your excuse. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea, the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, this GPS tracking device, that was for the ankle, correct?
Yes, Your Honor.
Maybe I'm missing in the police report, but I'm trying to find where it says that he didn't have it. All right, anyone else ready? All right, are you all ready on McCaskill?
Yes, Judge.
Okay,
Have copies of the witness.
yes,
We have agreements that will help.
yes, you know, are they out here? McCaskill?
Mr.
Yes.
McCaskill, yes, Judge, he's right.
McCaskill,
Hiding behind the top.
come down.
He's hiding, not hiding, but
Oh.
he's sitting there. He didn't, I don't want to say hiding like.
All right,
hiding.
Brenda McCaskill,
He's here.
come down, please.
You just can't see him. He's out of your line of sight. I should have
All right.
said, not hiding, hiding. with
And
the
I'm not wearing glasses at this time, so let me put those on.
There you go.
So one of these is for the motion to revoke, correct?
Yes, Judge.
And the other one is for our new case?
Yes, it's a 25 CR 008059.
All right. Court is calling 2024 CR 4372 and 2025 CR 008059 State versus Brandon McCaskill. Can I have parties announced?
Galloway for state.
Charles Bunk for Mr. McCaskill.
And are you Mr. McCaskill? All right, defense, you filed two motions requesting that a bond be set in each of the cause numbers. Is that correct?
Yes, Your Honor.
All right, is there a proposed agreement?
Yes, Your Honor.
And under the 4372 number, what is the proposed agreement?
40,000.
And in the 8059, what is the proposed agreement?
20,000.
I'm sorry?
20.
All right. Is either party asking for conditions?
No, Judge, just for him to comply with the, go back to probation and comply with probation and the conditions of probation while we're working on the resolution of his matters.
All right, you want to raise your right hand for me, please? Do you solemnly swear and affirm that the testimony you give will be the truth and nothing but the truth to help you God?
Yes.
All right, you can lower your hand. The questions I'm going to ask you are not about either one of the cases. It's just questions so I can make a determination on the appropriate bond to be set for you and appropriate conditions. So, in the past, have you ever had any type of mental health diagnosis? All right. Have you in the past ever been required to take any medications for mental health? All right. In the past, have you ever used any type of controlled substance? Marijuana, cocaine, meth? Okay,
Not cocaine.
okay, marijuana?
No hard drugs, marijuana use.
All right. Anything other than marijuana in the past? All right. This is what the court will do. The court will set your bond and cause number 2024 CR 4372 to $40,000. The court will order regular UAs and the fees will be waived. And cause number 2025 CR 008059, the court will set your bond at $20,000. And the court will order regular UAs, waive fees. And
And Judge, will the drug testing, I anticipate when he makes the bond, he's reporting to his probation officer.
well,
You want to test through probation or test through pretrial services or both?
probation has informed me that once there's a motion to revoke file, there is no reporting to probation or doing testing
Oh, okay.
there. Is that correct, probation?
As long as the case is still active, he reports. He's supposed to report.
No, but I was told that you all would not drug test or do anything else.
Can't amend the condition for that until, because it'll close DPR.
So they won't do that.
That's fine.
So you have to do that through pretrial services.
Whatever the court would like.
All right, so is this gonna, we're off the record, is this gonna be a contested MTR?
I don't believe so.
Uh,
I think no, I don't believe it's gonna be contested.
All right, Ms. Ferguson, on this case, is you bring it back in 14 days? Okay. All right, February 23rd.
Okay.
All right, we'll see you back on February 23rd. Norma, he'll need a reset, please. You're welcome. Oh, you too.
Let's see, I'll let you sign this.
Leaving the white target.
Oh, there we go. Yes.
Judge, I've spoken to defense counsel. He's seen the addition to the stipulations and believe it should be kosher now.
All right. So we're back on the record in 2025 CR 014814, State versus Sebastian Gabriel. It's the court's understanding that the state has amended the stipulations. Is that correct, State?
That's correct, Judge.
And defense, you have any objections to the amendment?
No, I do not, Judge. I've reviewed those amendments and have no objection to them.
All right, so off the record for a moment. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Ask you follow the agreement, Judge.
And counsel, did I give you a copy?
You did.
I did, okay. All right, the court will sentence you to 2 years in the prison. Give you credit for any time served. This will run concurrent with 2023 JUV 00249B. Take in consideration 2026 AL 000120, 2026 AL 000122, 2026 AL 000123. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? And counsel, I'll request the therapeutic community just so it's there if he feels as though he needs it.
Yes, Your Honor.
The therapeutic community doesn't increase the time that you're in custody. It's really designed to help you rehabilitate yourself. I do not have the authority to force them to place you in the program, but they'll see that I think it's should be recommended, but you'll still have to ask for it, okay? All right, we can go off the record. How old are you?
19.
All right, so here's the thing. This is not the end of the world, right? And I know any time that you do time is a lot of time. But if you don't change your ways and make better decisions and get your life in order, you're gonna end up in prison a lot, okay? So do better. When you're released from prison, if you're lost and trying to find your way, if I'm still here, you come back here, I will do my best to put you on the right track, okay? And while you're at the prison, if you haven't obtained your GED or anything, work the program, get your GED. You can get trade school. And I will tell you, one of the best professions for people who have criminal cases usually is welding. Welding is very dangerous because you're dealing with sparks and everything, but it pays a lot. And when I was a practicing attorney, I had a lot of clients who had been in prison and served 20 years. And they got their welding and it went great. So good luck, okay? All right. All right, are you all ready on Brian Berry?
We've reached an agreement, Your Honor.
Okay.
Brandon.
All right, could I have Mr. Berry approach? All right, we're back on the record in 2025 CR 011568, State versus Brian Berry. Could I have parties re-announce?
Ready for the state?
Matthew Brown for the defense.
And it's the court's understanding that you all have amended your agreement?
Yes, Your Honor, that's correct.
All right. So according to the plea bargain agreement, do y'all have the? Y'all have to write.
Can we amend that one?
Oh, not on that. You just have to print out a new and just do amend it.
And attach it here? Of
Yes.
course, Judge, you may have a moment.
Yes,
My apologies.
no problem. And Deputy Laura, after this, we're gonna take our break. Oh, Norma, can you call Barbara Schaefer? Yes, I'm supposed to meet with her today. All right, we're back on the record in 2025 CR 015568. It's the court's understanding that you've amended your plea bargain agreement. Is that correct to both sides?
That's correct, Judge.
Yes, Your Honor.
And according to your amended plea bargain agreement, punishment is to be assessed at 2 years in the prison. And there's restitution of $500 to the complainant. Is that correct?
Yes, Your Honor.
Is that correct, sir?
Yes, ma'am.
All right. As previously stated, the court will find there is sufficient evidence to find you guilty. The court will find the enhancements true based upon your plea of true and based upon States Exhibits 1 and attachments. The court will sentence you to 2 years in the prison, give you credit for any time served. There's a $500 restitution to the complainant. Is there anything else with regards to sentencing?
No, Your Honor.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Okay, because I'm supposed to meet with her today. All right, thank you. All right, everyone, the court is going to go on recess.
We're gonna have two more